Colleagues, in June of 2016, the California State Supreme Court published its ruling in the case of People versus Sanchez. The case came out of my county's Superior Court with my good friend Judge Stephen Bromberg presiding, a former mayor actually of Newport Beach. It completely changed an attorney's ability to present hearsay evidence through expert testimony. I tried to address this change last year with SB 1276, but we needed more time and did some work in the break and had some fun putting this together as it relates to dealing with family law cases. For a period of time during my accounting practice days, I served as an expert witness in divorce cases, assisting a spouse in a marital dissolution, the old classic forensic accounting where I would review the books and records of the business owner and try to determine revenue streams, overhead costs, and valuations. I would testify in court and I would provide written statements, and this is just basic hearsay evidence. The Sanchez case has stopped the use of expert witnesses. Now the actual evidence needs to be brought into the courtroom, including bank statements and related records. One recent case in Orange County alone required 100,000 pages of records to come into the courtroom. Colleagues, this is expensive, and on occasion, it's retaliatory behavior. What makes it more frustrating is that there is no jury in a divorce case. Parties appear before a judge. The fear of confusing a jury is not applicable. SB 435 exempts the Sanchez decision requirements from family law proceedings. This bill should reduce delays and costs. Not allowing an expert witness like a psychiatrist makes presenting evidence on mental illness concerns of one of the spouses extremely difficult. Pulling into court individuals familiar with children involved in a custody battle can put a major imposition on school employees and others. SB 435 attempts to provide more flexibility regarding the rules of evidence for judges who are better able to assess the reliability of testimony related to a case. Restoring the prior standard of proof in family law courts will remove a logjam that has added to the pain, turmoil, and anxiety resulting from the broad application of the Sanchez case. I want to thank the Association of Certified Family Law Specialists for their assistance, and I have Michelle Brown as my witness.
Good afternoon. 2 minutes, please.
Thank you. Good afternoon, Senator and members of the Senate Judiciary Council. I am the Vice President of the Association of Certified Family Law Specialists, and I've been in the trenches practicing family law for over 20 years. And I want to thank the Senator because he seems to understand the fact that family law is different. We're not a civil contract dispute. We're dealing with children, custody, and where they're going to live. And Sanchez contradicts the public policy of the state of California, which is to promote settlement among family law cases. Sanchez has had the complete opposite and has thrown family law cases into massive litigation. It has exponentially increased trials. Previously, where you'd have a court-appointed child custody evaluator or a court child custody recommending counselor. And I want to point out that these are legislative mandated. Family Code Section 3111 provides for the child custody evaluator. Family Code Section 3183 provides for the court recommended custody counseling recommended counselor. In these situations, they are legislatively mandated that they can provide an evaluation to the court. These independent custody evaluators talk to CWS workers, pediatricians, therapists, third-party collateral contacts, police officers, review all the independent data. Then they provide to the court, as the court's expert, a recommendation for what the best interest of a child. When Sanchez has come out, now in order to get that report into evidence, the proponent of that report has to provide a subpoena to every one of these persons in order to get that report into evidence. How does that hurt children? Well, ladies and gentlemen, the report that the proponent that wants the report to come into evidence is usually because the evaluator recommends that the child should be placed with one parent. The parent to whom the evaluator felt it was not in the best interest of the child doesn't want that report to come into evidence. Jumps up, says objection, Sanchez, and here we are 2 years down the road without any resolution for that child. I urge your aye vote.
Thank you very much. Are there other witnesses in support? Are there witnesses in opposition? If you'd step forward.
Sorry, Aaron.
All right. 2 minutes each, please.
Good morning, Madam Chair and members of the committee. My name is Andy Liebenbaum, and I'm here on behalf of the Judicial Council of California in respectful opposition to SB 435. First and foremost, there's no reason to treat family law differently from other civil case types in terms of evidentiary standards. Exceptionalism in the law, particularly when it comes to evidentiary latitude and hearsay exceptions, is a black hole of mischief and simply makes the work of the courts more difficult. The author claims that the underlying need for SB 435 is to create efficiency in the family courts and to speed the proceedings. There's no reason that family court litigants should experience reduced scrutiny of evidence for the sake of greater speed in court. Since many judicial officers throughout California and their clerks work in a variety of case types, creating a distinction in evidentiary standards of this magnitude in one case type should be supported by data about courtroom inefficiencies, problematic procedures, to support the need for changed judicial and staff training, new rules of court, and different court procedures. While efficiency is imperative, speed is not its equal. The job of the court is to ferret out the facts in as efficient manner as possible, providing an advantage to one party by allowing that party to push through reports and information beneficial to that party by avoiding the fair and tested rules of evidence and hearsay could speed things up, but without a corresponding emphasis on what is just, and by burdening the court with information that cannot be checked or verified. This limits the role, authority, and discretion of the judge. The vast majority, between 85 and 95% of family law litigants are unrepresented, and that means both parties are unrepresented. The stated need for hearsay exceptions is embodied in this bill, then, inure to the benefit of a fraction of family law litigants, namely those with means. It is the availability of resources, then, the ability to litigate at all, and more strategically, the financial capacity to authorize reports and push for their admission into evidence that makes family court proceedings take a long time.
Next witness.
Erin Ryberg on behalf of the California Judges Association. And first, I want to say we align ourselves with the Judicial Council and all the concerns that have already been raised. And we'll emphasize that our number one concern is that family law litigants will be treated differently than other litigants, even within the civil system of which family law is found. And the family law litigants are entitled to these same protections as other litigants in the law. And as Andy also mentioned, the high amount of litigants that are unrepresented in this area further shows why these evidentiary protections are necessary to protect the litigants. And while we're willing to work with the author and sponsor to discuss their issue, but we feel that SB 435 is too broad given the priorities that are at stake. Additional concerns that we've outlined in the letter that were also pointed out in the analysis deal with the shifting of the burden. This is, we're unfamiliar with any other area in the law where the burden would shift to the opponent to prove that the evidence is hearsay and therefore unreliable. Also, many of these reports are prepared by private experts paid for by one of the parties. So if they are paid for the report, they've paid for the representation, and then to have the unrepresented party be forced to go into court and then again oppose certain parts of the report as hearsay without actually having the information necessary to prove that. And so shifting the burden. And then finally, the report's accessible. I know I've never seen my medical record. I know that there's a lot of issues out there with whether, people are allowed to see it, what's in it. The fact that these reports would just be able to come in without somebody knowing what's included in the report and being able to cross-examine that person who relied on that medical expert's opinion. So in respectful opposition to SB 435.
Thank you very much. Are there any other witnesses in opposition?
Chair and members, actually I'm here in support. I was just a little late. Alejandra Duran on behalf of Change for Justice in support.
Thank you. Are there any other witnesses in support? Are you in support? All right. Witnesses in opposition. That wasn't a trick question. I'm sorry. All right. Other witnesses in opposition.
Hi, my name is Kelly O'Hara. I'm a third-year law student at UC Berkeley and a law clerk at Family Violence Appellate Project.
And they are opposed. All right, very good. So we're clear who supports, who's opposed. All right. Any questions from the dais? Senator Borges?
Thank you, Madam Chair. Quick question. Senator Morlock, the bill requires the proponent of the hearsay evidence to produce the witness. It's on. Oh, is it just not loud enough? There, I'll speak closer. It says that the bill also requires the proponent of the hearsay evidence to produce the witness for cross-examination upon request if the custody expert substantially relied upon information the hearsay declarant in making his or her recommendation. Can you help me better understand how is this transforming the requirement to produce the witness for cross-examination that's different than what we have right now?
May I defer to my legal counsel?
Oh, sure.
Yes, so there always, and there's been a bit of a misnomer, there's always the right, and under this proposal bill, there's the right to cross-examination. Right now, as I was stating previously, if you have a custody evaluation report and there's 30 collateral contacts, one person jumps up and says, I object to the report, Sanchez, you have to bring in all 30 of those people to try to get that report into evidence. Where this is saying is if there is somebody to whom the custody evaluator substantially relied upon in making his or her recommendations to the court, then the proponent of that report has the burden to produce that witness for cross-examination if the other parent says, look, I want to cross-examine the school teacher who the custody evaluator substantially relied upon, then the proponent of that report has the burden of proof to produce that school teacher so that the other parent has the right to cross-examine it. That was something we discussed last year with SB 1276 to alleviate some of the concerns that the judges had with regards to cross-examination. But the proponent of the report doesn't have to produce all 30 witnesses to get the report into evidence.
If this were a non-family law scenario, would all 30 have to be produced?
I don't really want to answer that question because I have practiced exclusively in family law for a very long time.
Yeah, the answer is yes.
You know,
Okay.
one thing that I also wanted to respond in that regard is I will tell you Sanchez has greatly hurt the lower income parent and the lower income spouse and the self-represented person. It is advantaging the higher income spouse and the higher income parent because that parent or spouse has the ability to jump up and say, objection Sanchez, if that report is against them, and say, I want a 20-day trial, and that lower income spouse turns to their attorney, and their attorney says, I need $200,000 to go to a 20-day trial.
You're asking for an exception here because unlike traditional civil actions, contractual issues, you're dealing with custody. And because of that, the very nature of what is at stake is fundamentally different than a dollar amount that might be in a contract dispute?
You're 100% correct. These are children. These are families. These aren't contracts.
We have all, I actually did some family law too, so you're not the only one in the room who's practiced family law. And perhaps some of my colleagues have had the misfortune of doing it as well. But there are a number of different provisions. You can stipulate to have a report go into the record. There are tremendous protections. This is an issue about hearsay. How far you're going to let hearsay in as the basis upon which an expert makes an opinion without any ability to validate that hearsay. That's what this bill asks for. So let's be clear on what the bill asks for.
All right. There was another question.
Any?
I think I'll come back. Please go ahead.
All right. Are there any other questions? I find it notable that the judges are opposed to this. I find it notable that Flexcom isn't supporting this bill. I also find it notable that 85 to 90% of litigants are representing. They're not going to know about these different kinds of nuances. And I would suspect that this is to to pass this legislation will be a boondoggle for those who are able to continue the process and provide for additional hearings to bring in this witness or not bring in that witness. There's a reason that hearsay has certain limitations to it. And what this bill, in my opinion, does is attempts to basically blow that apart and on the basis that this is going to be more protective of children, which I don't think it is, because again, you're allowing someone to make allegations and statements that are hearsay. I mean, that are out-of-court statements that are being offered for the truth of the matter asserted, that form the basis for reports, form the basis perhaps for even an expert deciding what property is community property and what property is separate property. So they're not necessarily child-based, if you will. These are family law cases where a number of issues are to be decided. I just don't understand why we should take away the protections that we have under the evidence code in this circumstance. And I would suggest that the fact that we don't have the family law bar itself coming in, that we have objection from the courts and judicial council really is a strong statement, and that this really is an overreach, and I think violates our rules of evidence that have been in place for a long time and for good reason.
Can I maybe create an example to flesh this out? So imagine an expert witness relies upon the school counselor's hearsay statement, and that expert witness is forming an opinion in a custody matter. You're saying that expert witness should have the ability to form their expert opinion upon the hearsay statement of that counselor to reduce the costs and allow that, if it's used as underlying justification for that expert's opinion, to bring that into the court system. And what you're saying is that normal hearsay would require that that counselor be brought in to substantiate what they said that was heard by the expert witness? I know that was a lot of information.
Yeah, so you're accurate in your statement that is one of the factors that the custody evaluator could do. That is the custody evaluator's job as a court-appointed expert under the Family Code. I think that's really important, is that Family Code 3111 is a legislatively mandated code that authorizes the appointment of child custody evaluators to do this exact thing and to provide reports to the court. And now with the Sanchez, they're saying, well, wait a minute, the legislatively mandated custody evaluator who is supposed to contact all these collateral resources for the court, now his or her report can't come into evidence. So your statement is correct that would be, if it was a school counselor, that would be one of the persons that the custody evaluator may talk to, and informing his or her opinion to the court as to what that person believes is in the best interest for the child. And previous, as I stated, if the other parent believes that was significantly relied upon, they can tell the other parent, you need to produce that school counselor for me to cross-examine. It doesn't stop the ability to cross-examine that witness at all.
So the law,
Let me maybe give another example.
excuse me, if I could, just so to clarify this. So an expert is entitled to make to form basic opinions and to articulate. I spoke to several different people. Based upon that, my general opinion is X, Y, and Z. They do have the ability to do that. But if they're taking the opinion of one person as fact, and I am relying upon that decision as fact, there is a hearsay opinion that is being used as a basis upon, it's not hypothetical. We often talk in hypotheticals, which we're allowed usually to use. Expert Senator Caballero, assume the following facts, and then you reach an opinion. But to say, I know that Mr. Smith had a conversation with the child who said, I hate my mother. so take that as a fact. Do you think that child should have to live with the mother? That's an example of the kind of thing where this would happen. So you take this extraordinary hearsay, it becomes the basis for the opinion that then is provided to the court and from which you're asking the court to make a finding that that child shouldn't live with the mother.
But still be subject to cross-examination, that individual.
Well, you could always bring that person in, but again, part of the problem is now you have to bring that person in. So that is,
That's the point.
well, no, but what you're doing is you are trying to use hearsay as fact. That's the problem. You're trying to use hearsay as fact, and there's a reason that we have had these hearsay laws, because they are not fact. They are not in and of themselves unless you have that hearsay exception that exists. But what you're trying to do is expand that exception here, and I think that that's why the courts are opposed to this. You can't do this in any other civil proceeding. And the courts, again, indicate they want to have that reliability so that we still have the rules of evidence rather than suspending the rules of evidence. There doesn't seem, I haven't found any good reason to suspend those rules of evidence in this kind of proceeding.
Small claims court, the rules of evidence don't exist. It's a court of equity, not a court of law. Are you trying to almost transform the family environment into a hybrid court of equity, not just court of law?
No, it's a court of law, but I will say that family law is a court of equity. It always has been. But there isn't, this case-specific hearsay isn't necessarily the facts admissible. It is the report that is admitted into evidence. I think that's a big distinction. The report of the custody evaluator or the CCRC, that's the Family Court Services, recommending counselors. The report is admitted into evidence to be considered. It doesn't necessarily mean all of the individual facts. It is what happens over almost 25 years of practice, I have never seen a custody evaluation that recommends a custody and visitation to parents based on one person. These reports are usually about 50 to 60 pages long, and they've talked to a number of different people. And again,
Could we have a response, perhaps, from those in opposition who are shaking their heads, if you'd like to respond to that?
Well, on Andy Liebenbaum for Judicial Council, I think procedurally, on the one hand, we've stated that the proposed law, the proposed bill would benefit a party that has greater means in a family law case. And at the same time, we've said that the vast majority of litigants in family law don't have access to any of this. But to put a finer point on it, if one party is represented and the other isn't, and a report is admissible under the terms of 435, and that report then is considered valid, so it's basically taking a third-party statements and giving them the imprimatur of validity by putting them in a report that then is admissible as hearsay evidence. But the other party doesn't have the ability to submit a report. They have to bring in their own witnesses. You have a huge structural imbalance that I think already exists. And I don't think that SB 435 addresses that structural imbalance and, in fact, makes more work for the courts in trying to make sure that there is equity and that there is an appearance that all parties and all needs are being taken care of.
And I would like, in response, the Supreme Court has also stated that the same judicial resources and safeguards should be committed to a family law trial as are committed to other civil proceedings. So appreciate the small claims issue, but a family law proceeding is, in fact, a court proceeding where the same rules of evidence, the same rights of litigants apply, and the court says should apply, as they do in other civil matters. So Without any other questions, Senator Morlock, if you'd like to close.
I would love to jump in here. Thank you, Madam.
Go for it.
Senator Borges, a couple goes through a divorce, and the wife says, I want to know what the value of his corporations is. And so hire a forensic accountant. They do 10 years of analysis, and they say, wait a second, we want to use Sanchez. So now all of a sudden you've got, in one case, 100,000 pages of bank statements brought into the court, certified by a bank employee that these are the bona fide statements, which then support what the research was that was done by forensic accountants. So you've added all these costs. I would say that Sanchez has been very expensive to family law, and in some cases has actually been acrimonious. It's like, I'm going to stick it to the husband because I can force him under Sanchez to provide all kinds of documents. And that was sort of the genesis of this bill. I had a family law attorney come and said, boy, this is just getting abused. So I appreciate the chairman's comment about how difficult family law is. I got out of it after a while. I served as an expert witness in divorce cases, and it's not a pretty area to work in. I just finally said, this is not where I want to focus time. With regards to Flexcom, they were supportive. They went neutral, that's my understanding. And not all judges are opposed, because I worked with judges this whole fall and winter to put this bill together. So all I'm hearing out of the testimony from the opponents is there's no reason to treat family law different than any other courtroom. And I'm making the argument that it is, that we have the ability to make family law courts more fair, more efficient, and less expensive. And that's why I respectfully request for an aye vote on SB 435.